This is an introduction to civil litigation. What is civil law? Civil law is defined as the body of laws dealing with the rights and duties owed by individuals and organisations to each other. Examples of civil law include buying a mobile phone, marriage, civil partnership and divorce, buying a house, renting a flat, distributing possessions of someone who has died, driving a car and causing an accident, and being dismissed from your job. There are other examples of civil law. What is civil litigation? Civil litigation deals with disputes arising from the various types of civil law. Typically, litigation and disputes can arise in a number of ways. Contract. Perhaps a breach of contract by failing to pay or failing to provide a service. Tort. A breach of a statutory obligation. An accident causing injury. Negligence are all examples of tort. Equity. Mistakes. Say I was meant to give you under contract £100 and I give you £1,000, then under the law of equity I am able to claim £900 from you. This is especially important in lack of contract. For example, you receive £20,000 from a family member to buy a house. They are not part of the purchase contract, but by paying £20,000, unless it is a gift, then they own some equity in the house. The civil courts. There are two courts where cases are normally brought or started. The county court, which is for cases up to £100,000 or £50,000 in personal injury cases. The county court also includes the small claims court. It also includes the online courts, i.e. money claim online or the online county court. And the county court also includes the European Small Claims Procedure, which still exists at least until the end of 2020. There is also the High Court, which is for dealing with cases over £100,000 or above £50,000 for personal injury. These deal with complex cases, which are split between the Queen's Bench Division and a Chancery Division. The Commercial Court, the Technology and Construction Court, the Circuit Commercial Court, the Admiralty Court, the Business and Property Court and the Companies Court are all separate divisions of the High Court. The scope of civil litigation. There is normally a claimant and a defendant, or in some cases an applicant and a respondent, and they are opponents in the case. There can be more than one claimant and more than one defendant in an action. This includes where a claimant brings a claim against a defendant, and includes the defendant bringing a claim against a third party in the same action. Cases are dealt with on the balance of probabilities. That means the court have to determine what is more likely to have happened in a set of circumstances, i.e. is there more than 50% chance. This is different to what you see in criminal courts, where the test is beyond reasonable doubt. The burden of proving the claim is with the claimant or the applicant. For example, it's the claimant who needs to prove that they should be successful. The defendant or the respondent does not have to prove anything unless they are bringing a counterclaim. So a defendant bringing a counterclaim is effectively classed as a counterclaimant, and they have to prove their counterclaim. If a case is proven, then the court is likely to deem the claimant has been successful and award a remedy. And the remedies can include compensation or damages, an injunction, specific performance, rectification, declarations, or restitution. So what does a claimant need to prove? Typically a claim can be split into three elements: liability, who is at fault, who is liable for the breach of contract, or who is liable for an accident. For example, quantum, the amount of money being claimed as a result of that breach or fault, or the amount of loss that has been suffered as a result. In personal injury claims, for example, quantum is the amount of compensation for the injury suffered, and the claimant has to prove that. In a case of contract, it's the amount of loss or damage that has been suffered as a result of that breach. And causation, how has the fault or breach caused the loss? Perfect example in personal injury cases is a road traffic accident happens, the claimant suffers a whiplash injury. The claimant needs to prove that the injury was caused by the accident and not by something else, like he had a whiplash injury caused by a sporting accident earlier in that day or the day before. To be successful, the claimant typically has to prove all three elements. For more information, visit our website, email us, contact us. You can even make an appointment or visit us. Please stay tuned for more presentations or subscribe to us. Thanks.